Good morning, everyone. On behalf of Environment Cell, New Law College Pune, I, Parth Raj Parashar, first year LLB student, welcome you all for today's session on Environment Impact Assessment. Today, for this session, we have with us Advocate Anirudh Hariani, member of Solicitor of Bombay Incorporated Law Society and an arguing counsel at Bombay High Court. Presently, Sir is associated with Chambers of Senior Counsel Mustafa Doctor. Sir has obtained his degree in law from Government Law College, Mumbai, and pursued his LL.M. from Cornell Law School. Advocate Hariani's association with environment law has been a key part of his career. As a student, he helped update a book on environment law written by senior advocate Shyam Diwan and Armin Rosenstrain. While pursuing his LL.M. at Cornell, he took environment law as one of his key electives. Sir has also been a visiting faculty for environment law at his alma mater, GLC Mumbai. Some of the key cases where Sir has marked his presence include a major mining case which further went to Supreme Court and resulted in complete stoppage of mining in Goa. He has worked on a number of PILs related to environment law. He appeared on behalf of Citizens Association and successfully argued to turn down the decision of municipal corporation to take over public park for development purpose. Recently, he appeared in matter involving environment aspect of the Metro 2B line being constructed in Mumbai. Apart from this, Sir has also been involved in several pro bono cases related to animal rights and has also been a guide to Bombay Port Trust where he assists them in utilizing the port lands. I would also like to welcome our principal, Dr. Bhagyashree Deshpande, for this session. Now, I would request Anirudh sir to take over the session.
Well, thank you so much, Parth, and apologies to everyone for the delay. I believe there were some technical issues. So today we are going to discuss the evolution of environment impact assessment and the process and how it really came to be. But before that, firstly, I'd like to thank New Law College for having me. And when you study about EIA or Environment Impact Assessment, you can't study about it in a vacuum. Because if, after all, it is a procedural law, it is pertaining to the procedure or the process of EIA. So therefore, we have to start this information on EIA a little prior to that. So we'll start with a few basic concepts of environmental law and the notions of how it grew. Then in the later part of this discussion, we will discuss EIA and what it means and the recent EIA draft notification of 2020. We all have different backgrounds and different levels of knowledge on environmental law. So it's good to preface the technical knowledge of EIA with the background of environmental law. And as far as possible, I'm going to try to stay away from all statutory provisions, but rather give you an overview of what the Indian environmental law encompasses. At the end of it, if you have any questions, I'm sure we can take them on Zoom, or I believe there's a WhatsApp group, so we'll take them up later. Now let's discuss what is environmental law. What is the study of environmental law? What does it involve? What is the scope? So environmental law is a relatively new field of law which seeks to redefine the relationship between human beings and nature by creating a sort of symbiotic system whereby both the natural ecosystem and industrial and material development sustain each other without deterring one another. So therefore, environmental law, in a sense, balances two rights. One is the right to a clean and healthy environment, and on the other hand is the capitalistic right or need to carry on one's trade or profession. And in COVID-19 times, on a side note, this is akin to the central government balancing the right to life by enforcing the national lockdown, and on the other hand, the right or necessity of people to practice their trade or profession and earn a living. So therefore, even in these COVID times, apart from COVID being a pandemic which threatens our very existence, it is in a sense a problem which is very much similar to an environmental law problem. So environmental law is the answer to environmental degradation, unrestricted exploitation of natural resources, and rampant industrialization. But why is it necessary? Why do we study environmental law? So according to me, it's necessary mainly because it is only through the threat of prosecution and penalty that we can reverse the long history of unrestrained material development. And by long history, I mean essentially since the Industrial Revolution. And this material development has led to environmental degradation. So we can somewhat reverse it or check the flow of it. And there's a concept which I will discuss called sustainable development, which is integral to this. So, therefore, as I mentioned, environmental law is the product of a value system that seeks to redefine human beings' relationship with the natural world. The essential idea or the main idea is to encourage us to act for the service of the environment and thus be of service to future generations who will also live in the same environment that we leave to them. And the basic purpose, therefore, of environmental law is to change the outlook or the attitude of people and to induce in them a mindset of sustainable development. Now, what is sustainable development? The words sustainable and development are indicative of what the phrase actually means. It is a concept which is deeply linked to environmental law and it has been defined in multitude of ways. But the most common definition is in a report titled Our Common Future by the World Commission on Environment and Development, also known as the Brundtland Commission, which was created by the United Nations General Assembly, and which report was prepared for the Rio Conference in 1992, in June of 1992. And we'll discuss about the Rio Conference a little later. But what is sustainable development? They defined it as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. And so, therefore, we study environmental law and sustainable development hand in hand. They go together. But apart from penalty and prosecution, which I mentioned earlier, is the main reason why we need environmental law. Environmental law is also the law of morality and justice. For example, our right to a clean and healthy environment is intricately linked to the fundamental right to life and liberty and a healthy environment enshrined in Article 21 of the Constitution, which, as we all know, is a fundamental right and inalienable right. So that's why we study environmental law. And now, for a brief period, I'll discuss on the evolution of environmental law and the evolution of EIA. So, religious texts and scriptures, such as the Bhagavad Gita, the Quran, the Bible, etc., have always encouraged that we be kind to our environment. Indian religious scriptures, particularly full of practical guidance of how to preserve the environment. And one of the basic features of Indian scriptures, particularly the Vedas and the Bhagavad Gita, are that they do not differentiate between human beings and non-human objects, whether living or not. Instead, they emphasize to see the image of the maker, the God, in every being, every atom of the earth. And this is also true that they instruct us to have mercy on animals. Similarly, in the Western world, the phrases Mother Nature or Mother Earth themselves are indicative of the fact that as humans, since time immemorial, we have considered nature to be precious. In fact, the phrase Mother Nature is a Greco-Roman phrase, a personification of nature that focuses on life-giving and nurturing aspects of nature. and they embody it in the form of mother. But this is, of course, ancient history. This was not law, this was just guidance contained in religious scriptures and ancient texts. The precepts of being caring to the environment, preserving its bounty, have been instilled in our minds since those days. But environmental law, that is, law which is rules and consequences of breach of those rules, relating to the environment, developed in more recent times. And by recent times, I mean about 500 years ago. The modern history of conservation can be traced back to 1669, when Jean-Baptiste Colbert, he was a French commander, he introduced the Water and Forest Ordinance, which can be seen as the precursor of environmental law as we know it today. And this pertained to the exploitation of natural resources found in forests, including water resources, riparian rights. And this was under King Louis XIV. France experienced a severe shortage of timber. So the minister of the state, who was a commander, Jean-Baptiste Colbert, warned the king that ongoing exploitation of French forests would threaten the economic warship and the French construction of commercial ships. And accordingly, the French political and economic power would diminish. So he introduced broad forest reforms that adopted the idea of bon usage de la nature, the good usage of nature, as one of its guiding principles. And this was a move which would influence all other forest reforms in Europe for centuries to come. And the essence, therefore, was natural resource management. It was not an idyllic scenario of protection of the environment. It was to manage your natural resources so that they would survive over a consistent period of time. And during this period, it became an essential element of international law, of public international law, in the form of bilateral treatments entered into between various states to settle disputes over shared natural resources. For example, if there was a dispute relating to riparian rights or the rights of a water body, then this was decided by way of bilateral treaties. There was no overarching environmental law. And the principle of reciprocity, which has today become a common principle of international law, was the guiding light behind these legislations. There were no specific environmental law legislations. All of them were bilateral or multilateral treaties that were entered into under the concept of territorial sovereignty. But it was also during this period that green policies for conservation of the natural environment began to make their appearance as treaties between various countries. For example, the Bayonne Boundary Treaty of 1856 between France and Spain was introduced for preventing the destruction of fisheries in a river which was shared between the two borders. And this led to the transformation and transition of domestic laws in relation to watercourses. And as we all know now, there's a developed field of law and a concept known as riparian rights, which means the rights to a water body or to the embankment along with it. So the initial motive of these environmental laws was self-serving and utilitarian. These were not statutes for the protection of the environment per se. These were statutes rather for convenience and for self-serving purposes. And some of the examples that developed around this time, around the late 1900s, around the early 20th century, was, I apologize, the late 1800s and the early 20th century were the 1900 Convention on Conservation of various species of wildlife in Africa that were useful to man or inoffensive, and the 1902 Paris Convention to protect birds which were useful to agriculture. But the key word here is that these were useful to humankind, useful for agriculture, and therefore they were sought to be protected. It was only in the early 20th century that the international environmental law really became a much more important thing than it was previously. And environmental law turned into conservation ethics for prevention of global environmental risks. In fact, in 1909, US President Roosevelt had first attempted to have a conference. It was called the International Conservation Conference, which was to be held in the Hague in the Netherlands. That was later called off. But in the early 1900s, there was the London Convention on relative uh, to the uh, to the preservation of fauna and flora in their natural state. This was held in 1933. There was a Washington Convention on protection of wildlife and preservation, which was held in 1940. And these were breakthroughs in the field of environmental law. And the non-governmental International Union for Protection of Nature was established in 1948, which later became known as the International Union for Protection of Nature and Natural Resources. And this became an important source for subsequent development in the field of international environmental law. So later, these combined initiatives of the UNESCO led to the adoption of the 1971 Ramsar Convention on Wetlands and the 1972 Paris Convention for Protection of World Cultural and Natural Heritage. And all these events ultimately led to the establishment of environmental law, which formed the basis of modern environmental law, which was and has been crystallized in multiple pronouncements of the Supreme Court and the High Court around the country. Now, briefly, let's touch upon the Indian law relating to environment as it was in the early 20th century. And initially, most people think that the Constitution of India always had specific provisions for protection of the environment. This is not so. The members of the Constituent Assembly were visionaries, but they themselves did not think that far ahead when it comes to the environment around them and to the natural world. So, when the Constitution was adopted in 1949, there were no provisions regarding fundamental duties of citizens, including the environment, though there was a part 3, which, as we all know, dealt with fundamental rights. However, Article 21 at that time was the right to life and liberty was narrowly construed. The expansive definition of the right to life and liberty only came much later, which we'll discuss. The fundamental duties of citizens were therefore added into the Constitution by the 42nd Amendment in 1976. And this was pursuant to the recommendations of the Swaran Singh committee that was constituted by the government. Now, Sardar Swaran Singh, he was an Indian politician and one of the longest serving cabinet members. And he was a chairperson of the committee entrusted with the responsibility of studying the Constitution in 1976 during the national emergency. As we all know, the national emergency was between June of 1975 and March of 1977. So soon after the declaration of the national emergency, Indira Gandhi constituted a committee under his chairmanship and tasked him the job of studying the question of amending the Constitution in light of past experiences. And based on its recommendations, the government incorporated widespread changes to the Constitution. Now, this doesn't only include amendments in relation to environmental law. As we all know, by the 42nd Amendment, which came into effect in January of 1977, the preamble of the Constitution was also changed and amended, and the words sovereign democratic republic were replaced with the words sovereign socialist secular democratic republic. So there were various changes which came in the 42nd Amendment, including the basis of fundamental rights, the basis of environmental rights under the fundamental duties and the directive principles of policy. So also, as I mentioned, there was the fundamental duties, and the committee also suggested steps needed to be taken to ensure that an individual did not overlook his duties while in exercise of his fundamental rights. So Article 51A was added, which dealt with the 10 fundamental duties of citizens. And this was the inclusion of fundamental duties was really brought to our constitution to be in line with Article 29(1) of the Universal Declaration of Human Rights. Now, what did this provide? And this is really the key. The Universal Declaration of Human Rights, proclaimed in 1948, said that everyone has the duty to the community in which alone the full and free and full development of his personality is possible. So there were duties to the community. And one of these very important duties under Article 51A G was the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for all living creatures. And of course, these were also based on the USSR or the Soviet Union's model of fundamental duties and were taken in to be tied in with Indian tradition, mythology, religion, and practices. So, as we discussed, since time immemorial, there have been concepts of being kind and careful with respect to the environment. And these duties really became a codification of the tasks integral to the Indian way of life. Now, the directive principles of state policies were also introduced by the 42nd Amendment, and a new Article 48A was included under Part 4, which was the directive principles of state policy. And as we know, the principles are guidelines given to federal bodies, or rather the state, to be kept in mind while framing laws and policies. They are not binding, they are not enforceable, but these provisions contained in Part 4 of the Constitution really are the principles laid down that are required to be considered in the governance of a country. And it's the duty of the state to apply these principles in making laws to establish a just and moral society. Now, these principles were inspired by the Irish Constitution, and the directive principles were basically the social justice, economic welfare, and foreign policy uh, principles which were covered under these directive principles. Now, Article 48A of the Constitution was introduced by the 42nd Amendment. And what this provided was that the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. So it was the duty of the state to formulate laws which would protect the wildlife and the forest in the country. Now, these are, of course, the softer provisions of the Constitution of India, but the main provision which is time and again utilized by lawmakers and utilized in PILs by both petitioners as well as the judiciary to uphold environmental law is Article 21 of the Constitution. Article 21 of the Constitution provides that no person shall be deprived of his life or liberty except according to the procedure established by law. Now, originally, life and personal liberty were narrowly construed, and it was deemed to mean literally his life or his personal liberty. That means that he will not be imprisoned or held unlawfully. Now, the scope of Article 21 expanded beyond the literal meaning of the right to life and to include a right to healthy environment. And this was based on the Stockholm Convention, which we'll briefly touch upon because we're running short of time. But initially, in the case of Ratlam versus Varichand, it's a 1980 Supreme Court case. It's a very famous case. Ecology and public health were to be prioritized under Article 21, is what the Supreme Court laid down, in a case where pollution was due to private polluters and unplanned town planning. And so they held that a pollution-free environment is a part of the right to life and liberty under Article 21. And similarly, the protection of life under Article 21 was the key attraction of various high courts, including in the 1987 case of the Andhra Pradesh High Court in Damodar Rao's case, where a park was ordered to be converted into a residential area. And the court said that this was contrary to Article 21. And the court held that the protection and preservation of nature's gift, without which life cannot be enjoyed, was considered as a part of Article 21. Then another case, very popular and well-known case, is the case of the Ganga pollution case, or the Calcutta tanneries case, which was in 1987. Of course, this was another case titled MC Mehta versus Union of India. By the way, two gentlemen, Mr. MC Mehta and Mr. T.N. Godavarman, have to be credited for really taking environmental law to places in India well beyond what it was previously. And they've both been serial litigants. Both have filed a number of public interest litigations. So in this particular case, the Supreme Court supported the view that the right to a healthy environment is part of the right to life under Article 21. And the court held that tanneries which were polluting the Ganga had to be closed down, even though it would bring unemployment, loss of revenue, etc., because the preservation of life, health, and ecology are the most important thing above anything else. And of course, this was followed in the famous case of Subhash Kumar versus State of Bihar in 1991, where the court held that the right to live is a fundamental right under Article 21, and it includes the right of enjoyment of a pollution-free water and air for full enjoyment of life. And they said that if anything endangers or impairs that quality of life in derogation of laws, a citizen has the right to recourse under Article 32 of the Constitution for removing the pollution. Now, we'll just briefly, we're coming to the period when the EIA really came about. And this really came about around the early 1970s, when we had this conference, which was known as the Stockholm Conference. It was the UN Conference on the Human Environment held in Stockholm from 5th June 1972. And it was UN's first major conference on international environmental issues, not on bilateral or multilateral issues, but on international issues, and marked a real turning point in the development of international environmental law and politics. So this was really the seminal convention which marked a change in modern environmental law and policy and procedures. So the conference was proposed by Sweden in 1968, and the main purpose of the conference, as per the UN General Assembly, was to serve as a practical means to encourage and provide guidelines for action by governments and international organizations. And it was designed to protect and improve human environment. Now, the General Assembly of the UN said that the conference would endeavor to promote and advance guidelines for action by governments and international organizations in relation to the environment. But it did more than that. By most standards, the Stockholm Conference was a raging success. And we talk about the Paris Agreement, and we talk about the Rio Conference, but this was the precursor to really the takeoff of environmental law globally. There were over 100 governments which attended and well over 400 non-governmental organizations, which was a huge amount of attendance for the first international global environmental law conference. And it resulted in the declaration of the Convention of Human Environmental Law and an action plan, which came to be known as the Magna Carta of Human Environmental Law. People who are familiar with the Magna Carta know that that's the basis of our civil liberties. But this was the basis of environmental law for the past 50 years. So the declaration recommended or proffered 26 main principles and warned that natural resources of the earth, including air, water, land, flora, and fauna, and especially the representative sample of natural ecosystem, must be safeguarded for the benefit of present and future generations through careful planning and management as appropriate. So the declaration stated that every human has the right to enjoy a clean and healthy environment, which is the basis of Article 21 in India being construed widely. Remember, this was in 1976, and thereafter, courts in India also construed the right to life widely on the basis of this charter. The responsibility to preserve the environment for future generations was a concept that came for the first time in the 1976 Stockholm Conference. And while the convention and the declaration contained many, lofty ideals and principles, there were several specific recommendations. So the action plan also contained proposals for dealing with pollution in general, but significantly, one recommendation, specifically recommendation 70, contains one of the first references to global climate change in an international document. And it reads that governments should be mindful of activities in which there is an appreciable risk of effects on the climate. So climate change, which is even today debated, and as we know, the premier of the US, Donald Trump, has denounced that there is in fact climate change which is human made. This was recorded as far back as 1976. Now, there were various agreements that came to be associated with the Stockholm Conference. We won't go into that. After this, in 1992, on the 20th anniversary of the Stockholm Conference, there was another conference which was held in 1992, which was the Rio Conference. The Stockholm Conference was in 1972, and this was in 1992. The location was very important because it sent a message that the environment and development were concerns of all countries. And as you recall, we discussed the Brundtland Commission report where the concept of sustainable development became a basic principle of international environmental law. But the Rio Conference also produced several other important documents on international environmental law, and just took the Stockholm Conference much further. Thereafter, you had the Paris Accord of, as we all know, it's an accord that it's within the United Nations framework on Convention on Climate Change. So the Paris Agreement or Accord dealt with greenhouse gas emissions, mitigation thereof, adaptation, finance, etc. And all this, it came about in 1998. As of February 2020, all the members of UNFCCC had signed the agreement, and most of them had become a party to it. But there are significant emitters such as Turkey and Iran, and now some countries such as the US are trying to renege from their obligations under the Paris Accord. So those were the international, really the international conventions and declarations that came about. Now, as discussed, the Stockholm Declaration gave impetus to India to adopt laws in relation to the environment. That was in 1972, and thereafter, the Indian legislature came out with the Water Prevention and Control Act of 1974, the Air Prevention and Control of Pollution Act of 1981, the Wildlife Protection Act of 1972, and the Forest Conservation Act of 1980, to name a few. And also, another very important thing happened in the early 1980s, which was the Bhopal Gas Tragedy, which occurred in 1984. It was really an eye opener for the government, and it necessitated the government of India to enact a comprehensive environmental legislation, which would include rules relating to storing and handling of hazardous waste. Eventually, the Indian Parliament enacted the Environment Protection Act 1986. And this is really the umbrella legislation which consolidated the provisions of the Water Act of 1974, the Air Pollution Act of 1981. And within the framework of these legislations, the government established pollution control boards, etc., etc. Now, the Environment Protection Act is really the genesis of EIA in India, and it authorizes central government to protect and improve the quality of the environment and control and reduce pollution from all sources. So therefore, we come to the concept of EIA, which is under the Environmental Protection Act, and which is really the concept that has percolated from 50 years of development of international law. So what does EIA mean? What does Environment Impact Assessment mean? It is a process, or really a procedure, of evaluating likely environmental impacts of a proposed project or development or construction or any such sort. Economic impacts, cultural and human health impacts, and it considers both positive and negative impacts. So it's not just a negative thing. Now, the UNEP, that is the United Nations Environmental Program, defines EIA as a tool to be used to identify the environmental, social, and economic impacts of a project prior to a decision being made on whether to implement it or not. So really, EIA aims to predict environmental impact at an early stage in the project and to find ways and means to reduce adverse impacts, to shape projects to suit the local environment, and to really predict the future by giving options to decision makers and saying that, look, this will result in an adverse environmental impact. So by using EIA, both environmental and economic benefits can be achieved, such as reduced cost and time of project, implementation and design, etc., etc. And similarly, the United States National Policy Act, that's the NEPA as it's known, defines EIA as a systematic interdisciplinary approach, which will ensure the integrated use of the natural and social sciences and the environmental design arts in planning and decision making. And this will have an impact on human environment. Now, why is it interdisciplinary? Because it's not just looking strictly at the ecology. It's also looking at the economic benefits, the social benefits, and the human health impacts apart from cultural, etc. So it's therefore an interdisciplinary approach. Now, what does EIA involve? Although each legislation and practice is different around the world, the main components of EIA generally involve several stages, 4 or 5 stages. The first stage is screening, which is to determine which projects or developments require a full or partial impact assessment study. The second step or stage is scoping, which is to identify which potential impacts are relevant to assess, to identify alternative solutions that avoid or mitigate such impacts on biodiversity or on the economy, and finally, to derive reference or terms of reference for the impact assessment. Thereafter, the third stage is assessment and evaluation of impacts and development of alternatives. So these are to predict and identify the likely environmental impacts of a proposed project and include a detailed elaboration of alternatives. And then lastly, there is 2 steps, which are the report on environmental impact assessment, the EIA report, and the EMP plan in cases of wider projects or in cases of development of townships and cities, etc. And thereafter, review of the environment impact assessment report or statement. Now, of course, after that, you also have to have compliance and enforcement of the EIA report. But these are the general stages which are involved in EIA around the world. This is what is there. Of course, in some cases, you also have public consultation, and we'll talk about public consultation shortly, because in India, that is one of the key features of the EIA system. So how did the EIA concept evolve? As we discussed in 1970, 1972, there was a great impetus to environmental laws. Prior to 1972, of course, they used to have project-based reviews, and there was a limited consideration given to environmental consequences. But after the Stockholm Convention and after the introduction of the NEPA in 1970 in the US, the basic principles of EIA were developed. Guidelines and procedures, including public participation and public consultation, were instituted, and standard methodologies for impact analysis were developed. And so in the early to mid 1970s, other countries also like Canada, Australia, and New Zealand came up with their own legislations relating to environment impact assessment. Thereafter, in the late 1970s and early 1980s, more formalized guidance came about. Other industrial and developing countries introduced EIA requirements such as France, Philippines, the Netherlands, and adopted elements such as impact reports as a part of development applications for planning permission. Now, the use of EIA by developing countries such as Brazil, Philippines, China, and Indonesia also began at around the same time. And there was always an emphasis on ecological modeling and prediction and evaluation methods. Then after that, in Europe, there came the EEC developed its own council directives, that is the European Economic Community. And they developed really the first, what is considered the first international instrument to provide for EIA, which is Council Directive 85/337 in 1988. And despite the limitations which became apparent, they introduced this directive and it has served as a model for subsequent legal instruments, which for which practical implementation has been discovered. Uh, Now we've come up to the 1980s. Now, in the 1990s, really in India, in the 1980s, we had the 1986 Act, the Environment Protection Act. And in the 1990s, the requirement to consider transboundary effects came about. And in 1994, India also formally adopted EIA. This was the first notification that came about in 1994. So, unlike the European Union and the US and other developed countries, we had in 1976 to 77, we had the Planning Commission, which asked the Department of Science and Technology to examine certain projects from environmental angles. But this was not in relation to each development on a private level. And this was also a very administrative process. It was not uh, it didn't have legislative support. So therefore, on 27th of January 1994, the Union Ministry, the Ministry of Environment and Forests, promulgated the EIA notification under the Environment Protection Act of 1986 and made environmental clearance mandatory for expansion, modernization of any activity or for setting up new projects as listed in the notification. Thereafter, there were 12 different amendments made in the EIA notification. And there's a very important or an interesting judgment of the Goa Foundation versus Konkan Railway, which was laid down in 1992 by the Bombay High Court. Justice Paintsay really laid down the judgment. And the grievance of the petitioners in that case was that a proposed railway alignment had been planned and undertaken without giving adequate uh, environment impact assessment and without really planning for the environment. This was, of course, prior to the 1994 notification. And the petitioners further claimed that as the proposed alignment crossed rivers, creeks, water bodies, uh, the municipal corporation could not proceed to carry out the work without obtaining the statutory clearance required under the provisions of the Environment Protection Act. Now, this was, remember, before the 1994 amendment, 1994 notification. And eventually, what was held by the High Court, the Bombay High Court, was that the corporation is right in its contention that industry's operations or processes does not include within its sweep activities of providing a railway line. So a railway line did not really need any environmental protection. And it also dealt with the Railways Act of 1989, in which Section 11 provided that notwithstanding anything contained in any other law, it was a non-obstante provision, the railway administration may, for the purposes of constructing a railway, uh, construct upon any lands, valleys, roads, streams, etc., etc. So they considered the wide ambit of the provisions of Section 11 uh, to say that it overrides the Environment Act. Now, the judgment firstly did not consider the EIA notifications of 1994 or the subsequent 2006 notification, which we'll talk about, since it was delivered in April of 1992, prior to their, of course, promulgation. And secondly, the judgment lays down a proposition that only permanent buildings or workshops which are not erected for the purpose of providing a railway line require prior clearance. Now, Section 11 of the 1989 Act was relied upon, but in my opinion, and it's certainly arguable that the judgment is distinguishable because it does not consider Section 24 of the Environment Protection Act, which provides that subject to the provisions of subsection 2, the provisions of this act and the rules made or orders made therein shall have effect notwithstanding anything inconsistent therewith contained in any other act. So basically, the wording of the non-obstante clause in section 24 is very wide and envisages that the same ought to have an overriding effect over laws not just in force at the time of the act, but also those that would come into force later. Now, also very importantly, the judgment overlooks Article 21, as we've discussed, and on account of subsequent judicial pronouncements, which we discussed several of them, the Supreme Court has given an expansive interpretation to Article 21, and therefore, in this judgment in 1992 could be distinguished if it were to be reconsidered today. In fact, in a later judgment of the NGT, that's the National Green Tribunal, in 2015, in the case of Vikrant Tongad, what the NGT held was that a metro railway project is covered under the EIA notification of 2006. Though, of course, this judgment is now under consideration by the Supreme Court, but this is the law as it stands as of today. Now, we've spoken about the 1994 notification. Let's speak briefly about the 2006 EIA notification. On 18th of May 2006, the Union Cabinet approved the National Environment Policy. And thereafter, a notification was issued by the central government in September of 2006, which is the EIA notification. And this notification was issued in exercise of the powers under Section 3 of the Environment Protection Act, specifically subsection 1 and 2 thereof, and Rule 53D of the Environment Protection Rules of 1986. So what does Section 3 of the Act provide, really? It says that the power of the central government to take measures to protect and improve the environment are very vast, and the central government shall have the power to take all measures that it deems necessary or expedient to protect the environment and improve the quality of the environment, and to control and abate environmental protection. And in particular, such measures may include measures in respect to restriction of areas in which industries, operations, or processes, or class of industries, operations, or processes shall not be carried out or shall be carried out subject to certain safeguards. Remember, this is the same phrase used in the Goa Foundation case. So now the 2006 notification listed out certain projects in the schedule of the notification, which can be undertaken only after prior environmental clearance from the central government or the state level Environment Impact Assessment Authority, SEIAA, as the case may be. So it categorized or decentralized the environmental clearance for projects by creating two categories, Category A and Category B. And Category A were projects that were appraised by the National Level Impact Assessment Agency and the Expert Appraisal Committee. And Category B were projects appraised at the state level by the State Level Environmental Impact Assessment Authority, the SEIAA, and the State Level Appraisal Committee. Now, Category A projects required mandatory environmental clearance, and they did not have to undergo the screening process, whereas Category B projects undergo screening process, and they are classified into two groups, Category B1 and Category B2. Category B1 mandatorily requires environmental clearance, and Category B2 does not require environmental clearance. Now, there was a 4-stage process which was stipulated under the notification. Firstly, there would be screening, which refers to the process of scrutinizing an application for environmental clearance to determine whether or not it is a project or activity which requires environmental impact assessment. And if it is not, then projects requiring environmental impact assessment should be categorized as B1, and remaining projects would be B2. Now, scoping is the second stage, which refers to the process by which the expert appraisal committee determines comprehensive terms of reference addressing all the environmental concerns, and it prepares an environment impact assessment report. Thereafter is the most important step, which is public consultation. Now, public consultation or public participation refers to the process by which the concerns of local affected persons or people who are in that locality and persons who have a stake in environmental impacts of the project are taken into account, and all category A and category B1 projects require public consultation. So this is really the essence of the EIA notification, public consultation. But in reality, the 2006 notification does not strengthen the public consultation process, which is one of the key areas of EIA. The notification defines consultation as a process for locally affected persons, but the 2006 notification does also includes a provision stating that if the situation is not conducive to conducting public consultation, then EIA can be foregone. So therefore, it is at the option of the government of whether to forego public consultation or not. In one landmark case of the Delhi High Court, this is the Samarth Trust versus Union of India case, which in 2010, the Delhi High Court considered EIA is a part of participatory justice in which the voice is given to the voiceless. And they considered it to be something like Jan Sunwai, where the community is really the jury. So it really involves the public into it. Also, public consultation was a outcome of the 1992 Rio Declaration, which says that environmental issues are best handled through participation of all concerned citizens. But the 2006 notification really diluted this provision. Thereafter, there's appraisal, which means the detailed scrutiny by the EAC or the SEAC of the application and other documents. And the final EIA report is produced or published. Now, another criticism of the 2006 notification was that the EIA was to be conducted only at the very end of the environmental clearance process, and therefore there was very little scope for the public to take an active role in the different stages of the process. Now let's talk about the 2020 draft notification. We're coming to the end of the talk. I know we're running out of time, but what are the main changes which have been introduced in the 2020 EIA notification? As we all know, in March 2020, the MOEF has proposed a draft amendment or a draft notification to replace the 2006 notification. This is at the stage of public comments. Now, the key changes that are introduced, and this is really the biggest grievance of environmentalists and of social activists and of lawyers, is that the new draft allows for post facto approval of projects, which means that environmental clearance can be given for projects even after they have started construction of those projects. And this also means that environmental damage caused by the project is likely to be waived off as violations get legitimized. And the only a deterrent will be the imposition of a fine or a penalty, which is post facto and which will not bring back the position as prior to the damage caused to the environment. So, this is in accordance with the polluter pays principle. And that principle says that you have to pay for the damage that you have caused. But here, really, the damage is already done. So, it does not reverse or does not prevent the damage from happening in the first place. Post facto approval is also in derogation of another fundamental principle of environmental law known as the precautionary principle, which is a principle of sustainability. And ultimately, what they will do is, even if the environmental clearance is not given, the damage will be done and we will be left with a fait accompli type situation where you cannot reverse the damage that has been done, and the government or even private actors will say that, look, we've already developed this project, so we can't reverse it. And this may very well be unconstitutional as well. Now, in 2017, Tamil Nadu High Court had struck down, or the Madras High Court had struck down clearance given to projects which was given after the projects had actually started. So this may be struck down, only time will tell. The second thing is the public consultation process has been reduced to 20 days from 30 days. And the fear is that unless a public hearing is really meaningful, the whole EIA process will lack transparency and credibility. And there'll be a reduction of time, which would pose a problem in those areas where information is not easily accessible, or in areas in which people are not well aware of the process itself. There's also an issue with respect to previously, under the 2006 notification, the project was proponent or the proposer was required to submit a 6-monthly project, a biannual project report showing that they are carrying out activities as per the terms of the permission which has been given. But the new draft says that the promoter will only have to submit a yearly report of the project, which of course is not ideal because many consequences which are irreversible for the environment may go unnoticed because of the extended reporting time. And then lastly, through the EIA process, through the draft notification, the central government has the power to categorize projects as strategic. And once it's considered as strategic, the draft notification provides that no information in relation to such projects shall be placed in the public domain. So really, it's making it less transparent and less in the public domain. And also, the draft notification provides that new construction projects up to 150,000 square meters instead of the existing 20,000 square meters do not need a detailed scrutiny. So they've really increased the size of the project, the threshold above which you need detailed scrutiny. So these are really the criticism of the current draft EIA process that is being proposed. I certainly hope that they make some substantive amendments if they are to eventually pass this draft notification. Certainly, cutting down the public consultation process or allowing for post facto approval should be a complete no-no, especially in current times when the environment is being completely degraded and there's complete destruction of our ecology. So what is the way ahead? Certainly, in the famous case of the Vellore Citizens Welfare Association versus Union of India in 1996, the Supreme Court observed that industry is vital for a country's development. But having regard to pollution, the doctrine of sustainable development must be adopted by them as really a balancing concept. if final environmental clearance is granted after taking into account the environmental, social, etc., health concerns of people, then it can be said that the government is using this process as a tool to ensure sustainability. I certainly hope that this 2020 draft notification gets the amendment that it needs, and that the public gives some good suggestions on how to amend it. And we are left with a robust and well functioning environmental law regime in the country after the 2020 notification is passed. So that concludes my talk. If there are any questions, I'm happy to answer them.
Yes, sir. Thank you, sir, for this session. We have a few questions. First, the
Sure.
basic one. It is from Ayush. He has asked that how should a young law aspirant approach to environment law as a career?
So now, really, initially there were a lot of pro bono matters which were happening, and it wasn't a paying uh, career. But I think in the last 20 years, things have really changed. Environmental litigation is a main kind of litigation which is being practiced in high courts and in the Supreme Court all the time. So, really, one has to develop an interest in environmental law, read up about it, and then take up any and all matters pertaining to town, town development, deforestation, anything, even pro bono initially, until you get until the practice is developed enough that you start getting paid matters.
Sir, another question from Shruti. She has asked that how can we look towards the Arai issue, the Arai forest issue in Bombay, in context of law?
So really, that's a complicated answer. That's uh, for a separate webinar in itself. Uh, but the RA issue is something which has been already challenged in the High Court, and it's really sad that it is coming down to grabbing of tribal areas and deforestation of thousands of trees when there are viable alternatives, at least in my opinion and in opinion of several environmentalists, to where you can have the metro to be the metro yards. So really, there, I don't think that it's ideal that it should have happened in the RA forest, and there should be some viable alternative.
Two questions from Mimanshi. She has asked that how has the environment law practice changed pre and post NGT since it was introduced and before that?
Absolutely. So the NGT Act was introduced in 2010, and now we have various tribunals all over the country which are dealing with environmental matters all the time. And it's completely transformed the practice, really, from being an, as I mentioned before, in the last 20 years, earlier it was a pro bono practice, and now it has become a really paying practice. The NGTs have their own bar, they have their own uh, regular matters, people who only practice out there. So it's really increased the environmental law in environmental law practice in India. It's revolutionized it.
So the question is from the same source. It is, will the Vista project be placed under the category of strategic importance, excluding all its docks out of public scrutiny?
See, this 2020 notification is not yet been passed. And secondly, we I really can't comment on individual cases, and we'll see how the law plays out, because we'll have to analyze what the fact situation is. But I mean, there's really no absolute answer. We'll have to really analyze the situation.
Okay, sir. Sir, I do had a question about mining, that government has recently decided to privatize coal mining, especially. So we have seen that how coal mining in past has created problem related to illegal sense that law cannot come in force where mining takes place. So how do you see this decision of making it privatized?
See, previously this is a completely a policy decision. Previously, the government had uh, made public all mining, all coal mining in the country at some point in different states, including West Bengal, etc. And it's a policy decision, but I certainly hope that this doesn't result in further degradation of the environment or result in some sort of a situation where uh, environmental clearance and permissions are given a go by. So, really, it's a policy decision to privatize it and to allow further licensing, but I don't know if it's ideal for the environment. And certainly, you'll have to consider each case on a case to case basis, on a fact basis, whether they are violating the law or not.
So we are done with questions. Do you have anything to add on it, sir? Lastly, I would like to ask you that.
No, I would just like to thank you for having me here, and I hope it wasn't too technical dry session because the EI notification really is something which is not very exciting, but we have to study it in the backdrop of environmental law as a whole. So I would like to thank you and thank New Law College Pune for having me. And really, this initiative of studying environmental law has been a great initiative. So kudos to all of you.
Thank you, sir. It was indeed a brainstorming session. Environment impact assessment has to play a major role, keeping in mind the development process and the sustainable development of utilization of resources at the same time. We are looking forward for it in the changing times where COVID has also came into play. So let's see how it works, and hopefully things will get right in the future. On behalf of New Law College Environment Cell, I would like to thank you for taking out time out of your busy schedule for this such an important session on environment law. I would also like to thank Dr. Bhagishri Deshpande, Principal, New Law College Pune, for supporting us throughout this session and for letting us organize this webinar on environment law. I would further like to thank our coordinator, Dr. Jyoti Dharma, and faculty coordinator, Dr. Jayashree Kandale, for being the pillars of Environment Cell and supporting us in conducting events. I would finally like firstly to apologize to all the attendees for the technical snag that we occurred and for the delay of this webinar telecast and everything. We would, on behalf of the entire Environment Cell family, I would like to apologize to them and further